Bilateral agreements with regional countries, Australia and Cambodia. In 2014, the Australian government faced political pressure in relation to relocating both people to PNG and Nauru. The two countries expressed that they would accept some of the asylum seekers from Australia, but were not prepared to accept all of them. In response, Australia searched for an alternative country other than PNG and Nauru to which it could transfer the asylum seekers. Finally, on 26 September 2014, Australia and the Kingdom of Cambodia signed a Memorandum of Understanding or MOU relating to the settlement of refugees in Cambodia along with related operational guidelines. Under the MOU, the asylum seekers who had originally tried to reach Australia by boat but were subsequently transferred to Nauru under the Pacific Solution would be resettled in Cambodia on the basis of permanent settlement. The permanent settlement will only be applicable to persons who were already recognized as refugees in Nauru and voluntarily accepted in writing the option of resettlement in Cambodia. The Cambodian government signed the resettlement agreement with Australia to accept the asylum seekers in exchange for money. According to the agreement, Australia would bear the direct cost of the agreement, which included assisting Cambodia in establishing appropriate arrangements for the refugees to re-establish their lives, including health insurance and temporary accommodation. Australia would also be responsible for the cost of the travel of Cambodian officials to the Republic of Nauru to provide information on the living condition, customs, tradition, culture, and religion of Cambodia to the refugees who might be settled. The MOU between Cambodia and Australia stated that the objective of the agreement was to expand protection opportunities and durable solutions for refugees in the Asia-Pacific region, and to demonstrate the importance of regional cooperation on refugee settlement in accordance with the Refugees Convention. However, human rights groups, especially Human Rights Watch, pointed out that Cambodia had a poor human rights record. It was unclear how the right of refugees would be guaranteed in Cambodia. Moreover, the actual purpose of the MOU wasn't responsibility sharing between the parties, but rather to shift Australia's responsibility for both refugees to other countries. The UNHCR expressed its serious concern about the Australia-Cambodia agreement on the relocation of the refugees. It maintained that this practice of relocation of refugees could set worrying precedent. Antonio Guterres, the UN High Commissioner for Refugees, remarked that this is a worrying departure from international norm. It's crucial that countries do not shift their refugee responsibilities elsewhere. This wasn't the global refugee system of international responsibility sharing. In fact, the Australia-Cambodia agreement violates the spirit of international refugee law, especially the non-refoulement principle, Article 33 of the 1951 Refugee Convention, as well as the international cooperation and burden-sharing commitments set forth in the preamble to the convention. Cambodia was another destination country for the boat refugee. Their targeted land was Australia. However, under the agreement with Cambodia, Australia provided a direct financial contribution to Cambodia of 55 million Australian dollars for the refugee arrangement, and in return, Cambodia agreed to accept the refugees. The true burden sharing of refugee protection doesn't shift by monetary agreement. Other actors need to be involved as well, such as the UNHCR and the human rights situation and domestic refugee protection system of the receiving country need to be assessed. After considering the evidence, this study contends that the Australia-Cambodia deal not only ignores international refugee law, but also indicates a gap in the protection regime where a state's obligation to refugees has been transferred to another country through direct financial dealing. The MOU was concluded initially for 4 years. Only 7 asylum seekers resettled to Cambodia under the deal. The agreement expired on 26 September 2018. The Australian government has not yet declared any plan to continue the deal. The arrangement faced severe criticism. It was described as collapsed and a ridiculous plan that cost just over 55 million Australian dollars. Apart from the Australia-Cambodia Refugee Agreement, Australia also made an agreement with Malaysia to shift its responsibility for refugees to that country. Australia and Malaysia. On 25 July 2011, the government of Australia and Malaysia signed a bilateral agreement for the transfer and resettlement of asylum seekers between the two countries. The operational guideline to support transfer and resettlement, or operational guideline, were also issued. The asylum seekers would be transferred from Australia to Malaysia under subsection 198A.3 of the Migration Act 1958. During the negotiation process of the agreement, the International Organization for Migration, or IOM, and the Office of the UNHCR were also involved. The bilateral agreement was achieved under the regional cooperation framework of the Bali process. Under the agreement, Australia will transfer a maximum of 800 asylum seekers to Malaysia. In response, Australia agreed to resettle 4,000 recognized refugees from Malaysia. The agreement was effective for 4 years from the date of signature. It applied to the asylum seekers who had arrived irregularly by sea in Australia or been intercepted at sea by the Australian authorities in the course of attempting to reach Australia. The Australian government agreed to bear all the costs and Malaysia agreed to provide all required assistance for the disembarkation and transfer of transferees. The agreement would be performed according to the country's respective international obligation. The agreement provided that operation under this agreement will be carried out in accordance with the domestic law, rules, regulation, and national policies from time to time in force in each country and in accordance with the participants' respective obligations under international law. However, the Australia-Malaysia Agreement put into question Australia's obligation under international and domestic law. In Plaintiff M70 per 2011 versus Minister for Immigration and Citizenship, Malaysian Solution case, the validity of the agreement was examined by the High Court of Australia. The plaintiff filed proceeding against their transfer from Australia to Malaysia. The key question was whether Australia, as a Refugee Convention signatory party, could involve a party that is not a party to the convention, Malaysia, that had no domestic law for refugees. In other words, Malaysia had no obligation under international law or domestic law. The full bench of the High Court by majority declared a permanent injunction on the Australia-Malaysia Agreement. The court ruled that the minister cannot sign an agreement for refugee settlement with a country unless that country has international legal obligation or its domestic law ensures effective procedures for refugee protection. Thank you.